Thank you for accepting this invitation. I invited you here today to address a matter of great public importance. The matter concerns a Petrotrin report which was sent to me by the Honourable Member for Parliament for St. Augustine, Mr. Prakash Ramada. That report raised serious questions concerning whether Petrotrin was justified in relying upon the accuracy of the internal audit report made public on a political platform in September 2017 to terminate the contract which A&V Oil and Gas Limited, hereinafter referred to as A&V, had with Petrotrin for the production and supply to Petrotrin of crude oil. This report, which was sent by Mr. Ramada, was concealed from the eyes of A&V, its lawyers, the courts, and the public. I would hereafter refer to the report sent to me by Mr. Ramada as the Supplemental Internal Audit Report, and the report which was released on the political platform in September 2017 as the Internal Audit Report. The Internal Audit Report contained accusations against A&V that A&V overstated its production and supply of oil to Petrotrin. Petrotrin made those assumptions as findings without having direct evidence against A&V of any overstatement of production and supply of crude oil to terminate its contract with A&V. Petrotrin represented to the public that they were findings and that they were independently confirmed by the Kroll and Klein reports. Petrotrin, in a media release in November 2017, told the public that the findings of the internal audit report were independently confirmed by Kroll and Klein reports. Petrotrin refused A&V and its lawyers to see the contents of the Kroll and Klein reports and to get copies of the said reports. Petrotrin was therefore relying on those reports, but it did not want A&V to get a copy of the reports, although it relied on those reports to terminate A&V's contract. The contents of the Supplemental Internal Audit Report, that is, report sent to me by Mr. Ramada, cast serious doubts on the alleged findings of the Internal Audit Report, and they can be regarded as nullifying any findings or assumptions made against A&V in the Internal Audit Report. The concealment by Petrotrin of this Supplemental Internal Report brings into focus whether the Kroll and Klein report supported the findings of the Internal Audit Report, or whether those reports, like the Supplemental Internal Audit Report, found that the measurement system and procedures of crude oil, which are supplied to Petrotrin by independent contractors, to have been inaccurate and unreliable. Petrotrin has claimed that the Kroll and Klein reports are confidential and privileged, but it cannot seriously do so since it publicly relied on those reports as the basis of terminating A&V's contract with Petrotrin. The Supplemental Internal Audit Report cannot be a confidential and privileged report to Petrotrin's eyes alone, since that report undermines the alleged findings against A&V in the Internal Audit Report which Petrotrin relied upon to terminate A&V's contract. Petrotrin is not a company owned by private shareholders. Petrotrin is a company owned by the people of Trinidad and Tobago in the name of the corporation sole. It is a government-owned company. Its earnings and its revenues belong to the people of Trinidad and Tobago. It has a duty to be open, transparent, and accountable to the public in matters which affect the national and public interests. Petrotrin depends partially on the revenue it gets from the production and supply of crude oil by independent contractors. A&V is one of the largest independent contractors which produce and supply crude oil to Petrotrin. If Petrotrin wrongfully or recklessly terminates an oil-producing contract of a contractor like A&V, that would adversely impact upon Petrotrin's revenues. Petrotrin's management and decisions are matters for public information because they involve the public interest. The financial problems of Petrotrin. Petrotrin is a state-owned company which employs approximately 5,000 persons. Petrotrin has been and is in need of revenue. Over the last 10 years, its revenues have declined. Petrotrin has over the years benefited from millions of dollars of revenue from A&V's production and supply of crude oil to it. On the 7th of January 2018, in a televised address to the nation, Prime Minister Dr. Keith Rowley said that Petrotrin owes the government 2.75 billion TT dollars, and its debt burden was now close to 15 billion TT dollars. Further, it was disclosed that Petrotrin has not paid corporation taxes to the government for 2 years. Petrotrin was also required to make a payment of US $850 million in August 2018 to an overseas lender, with another payment of US $750 million due in 2022. On the other hand, AV invested over $1 billion in the Catskill field to increase the production of crude oil, and the government would not be encouraging private sector investment in the country if a government-owned company is allowed to be secret and unaccountable in its dealing with investors. AV's massive investment. AV, through its aggressive drilling program, drilled 43 new wells between February 2016 and July 2017, and its production peaked in June 2017, when its cluster drilling program supplied large volumes of crude oil to Petrotrin from multiple wells at the same time. AV has produced evidence to show that it expended over $1 billion in capital and infrastructural investments in the Catskill field over the last 8 years in order for the oil wells to produce at maximum capacity. The internal audit report. That is the one which was released on the political platform. The authors of the internal audit report, dated the 17th of August 2017, relied on Petrotrin's systems and procedures to measure and assume the quantities and volumes of crude oil supplied to it by A&V. Relying on those systems and procedures, Petrotrin's internal audit report assumed that A&V overstated its supply of crude oil to Petrotrin. The reliability and accuracy of these assumptions in the internal audit report against A&V were dependent, obviously, on the accuracy and reliability of Petrotrin's systems and procedures for the measurement of crude oil supplied to it by A&V. A&V publicly denied the allegations of these assumptions in the internal audit report. It disputed the basis of Petrotrin's measurements and procedures to conclude that A&V overstated its production and supply of crude oil to Petrotrin. AV rejected Petrotrin's data, measurements, and assumptions on which it relied to make its assumptions or findings. The supplemental internal audit report, which I'll come to shortly, shows that there were merits in AV's denials because it found that Petrotrin's measurement systems were capable of making errors and assuming overstatement of the production and supply of crude oil to it, when in fact there was no such overstatement. Background facts which led to the termination of AV's contract with Petrotrin. In order for members of the public to understand the grave injustice which Petrotrin did to A&V and to the public interest, it is necessary for me to state briefly the facts which led to the termination of by Petrotrin of A&V's contract with Petrotrin. I would then examine with you some of the evidence in the supplemental internal audit report which Petrotrin concealed from A&V and from the public. After the internal audit report was made public on a political platform in September 2017, and the assumptions in the report that A&V overstated its production and supply of crude oil to Petrotrin over a period of 6 months were also made public, Petrotrin informed the public that it intended to have the findings in the internal audit report independently confirmed. It took steps to have the authors of the Kroll and Klein reports to confirm the findings in the internal audit report. Petrotrin, however, never disclosed that the supplemental internal audit report existed and that its contents undermined the findings of the internal audit report which Petrotrin was talking about. Petrotrin also did not give A&V any opportunity to be heard to answer any allegations against it before it compiled the internal audit report. or the Kroll and Klein reports, or the supplemental internal audit report. On the 17th of November 2017, Petrotrin issued a media release to the public, informing the public that it obtained 2 reports, one from Kroll Consulting Canada Company and the other from Gaffney Klein and Associates. It stated that these 2 reports provided independent confirmation of the findings of the internal audit report. Petrotrin denied the request of A&V to get a copy of each of those reports. At that time, Petrotrin knew that the supplemental internal audit report existed, which it had in its possession, and which report contained adverse findings against the measurement systems and procedures used by Petrotrin in the compilation of the internal audit report. AV, its lawyers, or the public, up to today, do not know the contents of the Klein and the Kroll reports, and whether in truth and in fact they support the alleged findings in the internal audit report. They also do not know what those reports stated about the said measurement systems and procedures which Petrotrin used to measure the supply of crude oil supplied to it by independent contractors. And we do not know whether those reports supported the findings in the supplemental audit report that the measurement system was skewed. We also do not know if the Kroll and Klein reports did an independent investigation of the findings against A&V in the internal audit report, or whether those reports merely accepted the data and measurements of Petrotrin and those reports merely rubber-stamped the findings of the internal audit report. We do not know. Upon AV receiving notice from Petrotrin that Petrotrin was terminating its contract with A&V and that A&V had to give up possession of the Catskill field, AV tried to get an injunction to restrain Petrotrin from terminating the contract pending the hearing and determination of the arbitration. The court, in determining whether it grants an injunction or does not grant an injunction, does not determine the merits of the cases of the respective parties. The merits of Petrotrin's case or the merits of AV's defense were therefore not determined by any of the courts. The parties agreed in their contract that any dispute relating to termination of the contract would be determined by arbitration. The arbitration has since been triggered, and the arbitrators will have to determine the merits of Petrotrin's case or its defense unless steps are taken to reconsider this matter and to have it sorted out. The proper course for Petrotrin to have taken if it wanted to terminate AV's contract was for the arbitration process to have been expedited in order for the arbitrator to decide the merits of Petrotrin's case and AV's defense, and in the meantime, until that was determined by the arbitrators, to permit the contract to continue pending the hearing and determination of the arbitration. Instead, Petrotrin decided to terminate the contract, took possession of the Catskill fields, and AV's valuable drilling equipment affixed to the soil at the Catskill field, and the merits of Petrotrin's allegations are not yet judicially determined. AV, pursuant to the enforcement by Petrotrin of its decision to terminate AV's contract, handed over the Catskill field to Petrotrin on the 2nd of February 2018. In handing over the Catskill field to Petrotrin, AV had to give up to Petrotrin all of its drill wells and production equipment, which were embedded in the soil as part of the drilling machinery in producing and supplying crude oil to Petrotrin. This included the well casings, the oil pumps, the buildings which are built, the access roads and drainage infrastructure and amenities. These were valued in the hundreds of millions of dollars. In addition to this loss to A&V, Petrotrin has not paid to A&V approximately $84 million for crude oil supplied to Petrotrin between the period 1st June to 3rd December 2017, together with another $12 million for crude oil supplied during the period 1st January 2018 to 28 February 2018, making a total of $96 million. How I received the supplemental internal audit report dated the 21st of August 2017. This report was dated only 4 days after the date of the internal audit report, and it was given to me by the Honourable Member of Parliament for St. Augustine, Mr. Prakash Ramada. By his letter to me, he stated that he received it in the mail at his constituency office and took steps to draw it to my attention. I will read the contents of his letter for the public. It stated as follows: please find enclosed a copy of a purported report dated the 21st of August 2017 of an internal audit at Petrotrin. The report arrived by mail at my constituency office at St. Augustine. Upon perusal of the findings, the findings are serious, and an action to remedy the failures are urgent. In an effort to inquire as to the authenticity of the report and to cause attention to be put on the issues raised, I, as MP for St. Augustine, filed an urgent question in the Parliament for answer on the 13th of April. The Honourable Speaker of the House, I am advised, disallowed the question. I will be making inquiries as to why the question was disallowed and have it refiled for answer. I consider it my duty to bring the findings of this report to light. To this end, you having taken many stands in the public interest and being involved in matters before the courts in Trinidad and Tobago on the relevant issues, I request of you to consider the report. I also ask that if you find merit to join in bringing this matter to the public attention and help to ensure the necessary remedies are administered. He attached a copy of the question which he wanted to ask the Honourable Minister of Energy in the Parliament. The question Mr. Ramada sought leave of the Speaker to ask the Honourable Minister of Energy is as follows: would the Honourable Minister of Energy inform this Honourable House whether he is aware of the contents of a recent audit report of Petrotrin dated the 21st of August 2017, together with a memorandum of the same date, which said report identified major deficiencies in Petrotrin's operating procedures for the measurement of crude oil supplied to it by contractors, and which cast serious doubts on the accuracy and reliability of Petrotrin's measurements. The said report also identifies most significantly a practice which, if continued, would be disastrous to Petrotrin's refinery and which can do serious damage to the national interests and economy. Also enclosed with this letter was the report headed Petrotrin's Internal Audit Report dated the 21st of August 2017, prepared by Petrotrin's Internal Audit Department. This document was headed Review of Controls Governing the Transmission of Crude Oil from the Fields to Pointe-à-Pierre. I have a copy of the report and I have a copy of the memorandum in my possession, which I got from Mr. Ramada. I also have his letters and the questions which he sent to me, the question which he sent to this Honourable Speaker of the House of Representatives. This supplemental internal report was accompanied by Petrotrin memorandum dated the 21st of August 2017, which was purportedly signed by Petrotrin's Chief Audit Executive, Mr. Rajkumar Bisesa, and was sent to Petrotrin's Vice President of Refinery and Marketing and Exploration and Production. This memorandum makes it clear that the supplemental internal audit report was a follow-up report to the first internal audit report. That is to say, this supplemental internal audit report was a follow-up report of the internal audit report which was released on the political platform in September 2017. It was dated only 4 days after the internal audit report. In the supplemental internal audit report at paragraph 10, page 3, it states that on the 17th of January 2017, Petrotrin's head of custody transfer requested Petrotrin's internal audit department to investigate shortages of crude oil received at Pointe-à-Pitre from the fields, and that Petrotrin's internal audit department conducted 2 audits and submitted 2 reports. The first one was dated the 17th of August, 2017. It is crystal clear that the supplemental internal audit report concluded that Petrotrin's own measurements of the volume of crude oil supplied by independent operators, including A&V, and which was sold to Petrotrin, are wholly inaccurate and unreliable because Petrotrin's own employees repeatedly failed to adhere to Petrotrin's standard operating procedures, and I will call it SOPs, leading to inaccurate fluid volume measurements. The supplemental internal audit report also commented on Petrotrin's poor crude collection, sampling, treating, and measuring procedures. It also complained about Petrotrin's employees' lack of training, inadequate management oversight of its custody transfer process, and inadequate tankage, pages 4 and 5 of the report. The effect of the findings in the supplemental internal audit report. The internal audit report at page 7 states, and I quote, that condensate is received from the central block, another joint venture operation, tank farm. The mix of fiscalized crude and condensate from the Bernstein and Barrackpore in-transit tanks is then pumped to the Philippine manifold, where all production commingles and flows to Pointe-à-Pitre via one pipeline. The effect of this technical information is this: crude oil supplied by independent operators and Petrotrin and condensate supplied from the central block and EOG end up at Barrackpore, while crude oil supplied by other independent contractors and Petrotrin and condensate from Atlantic LNG end up at Bernstein. Both tank farms pump crude to a manifold at Philippine, where they commingle and are sent through a single pipeline to Pointe-à-Pitre. Inaccurate measurements of condensate will also adversely affect the accuracy and measurements of crude oil supplied by independent contractors to Petrotrin. In summary, the internal audit dated the 17th of August 2017 claimed that there were shortages, that is, less crude was calculated as being received at Pointe-à-Pitre than was being sent from all input points throughout Petrotrin's operation, including condensate input from Atlantic LNG. So that is what the internal audit report of the 17th August claimed. That is the one released on the political platform. The internal audit report attributed these shortages to A&V, whose production and sales volumes were showing significant increases over the period under consideration because A&V was conducting an intensive drilling program at the time. The attribution of these shortages entirely to A&V implied that all other gross fluid and water measurements to calculate net oil at all other input points and at Pointe-à-Pitre were accurate, and that all measuring systems were properly implemented and meters were installed, were calibrated and working properly, that there was sufficient infrastructure in place with no losses in the oil transmission systems. If these things were not in place, then the basis for Petrotrin's suspicion of malpractice by A&V would be flawed and subject to serious challenge. The supplemental internal audit report dated the 21st of August 2017 dealt with the controls governing the transmission of crude and was headed Review of Controls Governing the Transmission of Crude from the fields to Pointe-à-Pitre and was submitted to Petrotrin Vice President. The conclusion of this supplemental internal audit report was shocking and clearly identify, among other things, a lack of adherence to standard operating procedures by Petrotrin's refinery personnel, inaccurate measurements of fluid volumes, poor crude sampling procedures, inadequate tankage for the proper treatment and storage of crude, poor supervision, lack of training, and poor contract management as serious defects in the system. Firstly, let's go into it. Firstly, it was found that while there were strict standard operating procedures, SOPs, governing the point-of-pay crude receipts, personnel charged with carrying out these tasks were not following the SOPs, resulting in serious errors in fluid volume determinations. Most worrying was that in random sampling, it was reported that the water and base sediment levels in the tank number 57, was higher at the low gauge when the oil in the tank was pumped down than at high gauge when the tank was full prior to pumping down. Such a situation can by itself contribute to a measurement shortage in the calculation of oil delivered to point-of-pay. Incredibly, even with audit staff in attendance, refinery personnel were conducting measuring and sampling incorrectly. The supplemental internal audit report therefore made several strong recommendations, including all samplers and gaugers should be issued warning letters for failure to conduct sampling and gauging tasks in accordance with the oil stock standard operating procedures. Point-of-pay custody transfer supervisor must ensure that water dips are redone when the free water level at high gauge is less than the recorded level at low gauge. The point-of-pay custody transfer supervisor and the plant superintendent production oil stocks should implement a mandatory gauging and sampling training program for all gaugers and samplers at point-of-pay. Secondly, the supplemental internal audit report recognized that tankage at point-of-pay for receiving crude from the fields, preparing the crude for sending to the refinery, and charging the refinery was woefully inadequate. Initially, 3 tanks were used for these purposes, but one tank, Tank 23, was put out of service in November 2016 for repairs and had not been returned to a service. A system of receiving, treating, and delivery of crude oil to the refinery needs a minimum of 3 tanks to be efficient. Accordingly, the auditors recommended that Vice Presidents Exploration and Production and Vice President Refining and Marketing must ensure that infrastructural repairs to storage and in-transit tanks are carried out as soon as possible. Thirdly, the supplemental internal audit report also found that there was a serious lack of management controls and monitoring of the supply of condensate from Atlantic Liquid Natural Gas, a company which supplied condensate from its liquefaction plant at Point Fortin under a contract with Petrotrin. The auditors found that the contract had expired 13 years ago, and shockingly no one was managing nor could say who was supposed to manage this contract, resulting in Petrotrin receiving unconfirmed quantities of questionable quality condensate into its system. The issue raises a serious concern about the lack of proper management systems in Petrotrin, and the auditors recommended that the vice presidents must ensure that there is adherence to the terms of agreement so that Petrotrin can account for the quantity and quality of condensate received. Fourthly, in a further area of poor operating practice, the supplemental internal audit report also found that crude entering the refinery was treated with de-emulsifiers in a very haphazard manner, not consistent with efficient and proper oilfield practices, and resulted in costly wastage and improper treatment of incoming crude, and the auditors recommended that the Vice President should ensure that the flow water and sampler are installed at a location prior to the de-emulsifier injection. A flow meter at point-of-pay would serve as an alternative check to confirm daily receipt of crude oil at point-of-pay. In summary, the auditors in the supplemental internal audit report clearly identified major sources of errors in the system which affected the accurate measurement of crude oil pumped to and received at point-of-pay, thereby contributing to the discrepancies between the volumes received and that pumped from the field. This audit clearly recognizes that the present system utilized by Petrotrin in receiving and measuring crude oil was seriously flawed, archaic, and desperately in need of urgent modernization as recommended. The supplemental audit report unequivocally puts the conclusion that of the internal audit report, which attributes the all volume discrepancies to A&V, in serious doubt. The measurement problem still exists, notwithstanding Petrotrin saying it fixed the measurement problems. Further, based on information I have received issued by Petrotrin at Pointe-à-Pierre, it is to be noted that in the month of September 2017, 2 months after Petrotrin changed its custody transfer employee assigned to the Catskill field, who Petrotrin alleged was involved in AV's overstatement of oil, and when Petrotrin stated it had fixed its measurement problems for the receipt of crude oil from independent operators after it implemented recommendations of the supplemental internal audit report, there was still a major difference in the crude oil pumped from the fields and that received at Pointe-à-Pierre. The actual volume discrepancy, as shown from Petrotrin's own records, was 33,977 barrels overage. Clearly, there still remained serious flaws in Petrotrin's system of measurement of crude oil supplied by independent contractors to Petrotrin, which have not yet been fixed. Important questions which arise. Some of the serious questions which arise from the findings of the supplemental internal audit report are: why did Petrotrin's board of directors allow the supplemental internal audit report to be concealed from the public and A&V? Why was Petrotrin's board of directors prepared to conceal this supplemental internal audit report, the contents of which raised serious doubts of the accuracy and findings contained in the internal audit report? Did the Minister of Energy have knowledge of the contents of the supplemental internal audit report? Assuming the Minister of Energy had knowledge of the contents of the supplemental internal audit report, why the Minister of Energy did not take action for Petrotrin to make the contents of the supplemental internal audit report available to the public and to A&V? If the Minister of Energy had knowledge of the memorandum and the supplemental internal audit report, why the Minister of Energy did not take steps to redress the miscarriage of justice done to A&V and to the public? What steps, if any, the Minister of Energy now intends to take in the light of the contents of the supplemental audit report? I intend to send a copy of this statement that I am making today and a copy of the report that I received to the Minister of Energy and to the Prime Minister as the responsible people in the government, because I think they have a duty to intervene in this matter. And I'll make a further statement of that in a short while. What does the government intend to do to correct the miscarriage of justice done to A&V and to safeguard the public interest in light of the contents of the memorandum and the supplemental internal audit report? By letter dated the 18th of April 2018, Petrotrin was informed by us that I had received the memorandum and supplemental internal report. That was sent to Petrotrin with the main purpose for Petrotrin to determine whether the report I got was authentic. I received a reply, and in that reply, Petrotrin has not disputed the authenticity of the report or the memorandum. Summary. Crude oil production from third parties which operate leases like A&V with Petrotrin makes up approximately 1/4 of the crude oil which flows through Petrotrin pipeline crude oil system. The other 3/4 of the volume of crude oil which passes through Petrotrin's crude oil pipeline system is produced by Petrotrin-operated fields. It appears that Atlantic LNG and natural gas condensate also pass through. It appears that Atlantic LNG condensate and natural gas also pass through the said pipeline crude oil system. Measuring the Petrotrin's production accurately is very important because errors in the measurement of Petrotrin's production and the production from other sources can have adverse effects on the measurement of another contractor and such as A&V. The contents of the supplemental internal audit report make me feel confident that both the Kroll and the Klein reports, which Petrotrin have concealed and which they are still concealing, have pointed out to Petrotrin that the measurement system and procedures which have been stated in the supplemental internal audit report as deficient are faulty and that they can produce errors and inaccuracies. And I wonder if that is the reason for Petrotrin's policy of secrecy in respect of these two reports. It is therefore very important for government to intervene and consider that it is in the public interest for the government to take steps to have these reports published so that the public would know the important facts about Petrotrin and other matters contained in that report, quite apart from its measurement systems. Further, the government has to take immediate steps to ensure that the measurement system does not produce errors, because we have seen up to September 2017, notwithstanding what Petrotrin stated that it had fixed the problems of overstatement of oil, the overstatement still exists. The lawyers of A&V are prepared to hold discussions with government and with Petrotrin in an effort to have the A&V matter resolved in the best interest of the public. Petrotrin suspected that it was not receiving the volume of crude oil delivered from the fields. The first step which Petrotrin was required to do was to ensure that its measurement system, which it used to establish any alleged overstatement of crude oil, was accurate and reliable. It did not do that. The supplemental internal audit report has clearly shown that its measurement system was flawed, and as such, the claim by Petrotrin of AV's overstatement of oil cannot be justified and supported with any evidence. The supplemental internal audit report would have been done because the internal audit report was grossly inconclusive against A&V and could not pass a suspicion test of A&V. The supplemental internal audit report is therefore very relevant to the issue of shortage, overage of receipt of crude oil by Petrotrin from independent contractors like A&V. Petrotrin has accused A&V and has penalized A&V's suspected misconduct in the delivery of crude oil to Petrotrin without first establishing that the claim is based on an accurate and reliable information and measurement system. This supplemental audit report went straight to the core of the issues, which shows that Petrotrin's claim against A&V of shortage and overage cannot properly be supported by its measurement system. Conclusion. It is important, in my view, in the national interest for government to promote a healthy investment environment in which investors are ensured that the government would treat investors fairly with openness and transparency. Investors therefore expect that a huge capital investment in respect of contracts with government and government entities would not be unfairly taken away from them or confiscated. The facts of this case show that important relevant facts and matters were concealed by Petrotrin from A&V, the courts and the public, which led to the termination of A&V's contract, causing a substantial miscarriage of justice to A&V. This concealment has adverse effects not only on A&V's business operations, but also the national economy, since Petrotrin's revenues have been substantially reduced because A&V is no longer selling crude oil to Petrotrin. Further, by its termination, Petrotrin has in effect confiscated A&V's drilling and production equipment and machinery, which A&V had been unable to remove from the Catskill field and has caused catastrophic loss and damage to A&V. I therefore expect that Petrotrin and the government will take urgent steps to redress these injustices in the national interest. I want to say before closing, I am sending the report with the statement, as I said, to both the Prime Minister and the Minister of Energy, because it is my view that any government in these circumstances, having regard to the facts which have happened, have a duty The government cannot justifiably say this is a state-owned company. It had a board of directors, and it could do virtually what it wants. These are grave injustices which not only apply to an individual company, but which apply to the public interest. I am not going to make the report available to the media as yet. I am going to give the government an opportunity to look at the report. If they do not have it, I would presume that they had it, because there are matters in the report which I do not want to be accused of divulging without giving the government full opportunity to consider whether the public interest demands the contents of not only the supplemental internal audit report, but the Kroll and Klein reports to be made available to the public. And I want to tell the government on Petrotrin, just as the supplemental internal audit report ended up in the hands of a member of parliament, I have no doubt that soon it is likely that the Kroll report or the Klein report may very well end up in some public figure, and I have no doubt that that public figure, if that public figure has the national interest at heart, would send a copy to me. And I want to give you the assurance, if I get those, as I get this, I'm going to bring you, I'm going to ask you to come, and I'm going to tell the national community about it. Thank you very much. Any questions? Anyone? I'm not seeing you.
Yeah, okay.
Sorry. Oh, sorry, Mr. Ali, I didn't see you there.
If it is found that the supplemental report was very material to Petrotrin's investigation, which they have bypassed, and rely only on the August audit report, does a cause of action arises against the management of Petrotrin?
Well, that depends upon a lot of facts which would have to be investigated. But in the light of what has happened and what I have seen, I am at this stage do not know whether the board of directors of Petrotrin had a copy of that report. Obviously, it is important for us to know that first. So I would expect there to be full disclosure, and I do not know if the minister, if the government had a copy of the report. So I do not know if the report was even concealed from the lawyers, the board of directors, the government. So I think that this gives an opportunity for us to know. If nothing happens and nobody talks and we do not know, then obviously we can infer certain things. But at this stage, I would not like to talk about any possible action against people whom I am not too sure whether they had knowledge of it or not.
Mr. Maharaj, now that you have introduced this new information, what action do you think should be taken by Petrotrin and the government, as a matter of fact?
If I were in government, and I obviously had no conflict of interest in this matter, because I would not have been a lawyer in the matter, I would have been in government. If I were in the government, this would be a matter in which the government would have to do either a few things. One, the government would have to find out, well, if the government knew of this and did nothing, well, then the government is at fault also. If the government did not know of it, and this was concealed from the government, this is a serious matter. And therefore, steps would have to be taken against Petrotrin, the officials, the board, or whatever it is. But in respect of A&V, it would seem to me that any objective assessment of this would mean that A&V was done a grave injustice. And therefore, there can be means whereby there can be discussions, and the arbitration can still continue if Petrotrin wants. The arbitration can continue, but there should be a way whether there could be a temporary contract for the oil to flow and for the arbitration to be expedited.
So what you are saying is that at the end of it, that AV will get contract will be renewed.
Well, I cannot say if it will be renewed because the government and Petrotrin would have to make that decision. What I can tell you is that no matter how many years the arbitration may take, it will just increase the costs and whatever damages and etc. But it is in that context, I believe, that the government has a responsibility because this sends a signal to other investors also.
Mr. Maharaj, based on your full presentation here today, it seems as though AV didn't have complied with all the requests by Petrotrin, right? In your presentation, you made mention that Petrotrin is at bankruptcy indirectly.
I didn't say that.
Indirectly, that is what you're saying,
but
that they're in
a poor financial situation.
Right. Is it possible that AV return some of these? I mean, based on they have complied with all their demands. They should be paying back Petrotrin this money that they are claiming that was.
You mean what Petrotrin was claiming?
Yes.
Yeah. Well, if it is that Petrotrin was wrong to make the finding against A&V based on this supplemental internal audit report, and we do not know what the Kroll report says, and we do not know what the other report says, but assuming they were wrong, then it means that A&V did not owe any money to Petrotrin. But what I'm saying is that if there are reasons to undermine what happened before, one way of dealing with it is for the arbitration to be expedited, for a judicial tribunal to determine, to be expedited, to be determined quickly, whether Petrotrin is right or A&V is right. But in the meantime, to find a way to have a temporary contract so A&V can continue to supply oil until the arbitration is determined. Normally, if you have something against an individual and the individual is disputing that allegation, you would not make the decision and then allow the person to determine whether he's right or wrong. You will have a judicial tribunal determine whether he's right or wrong and then take action. In case of A&V, the action was taken against A&V. They lost their equipment on the field, and now it turns out that the findings on which Petrotrin relied upon has been grossly undermined.
Mr. Maharaj, you mentioned that this document was purportedly signed by Mr. Rajkumar Bisasa, right?
Yes.
You also said that you wrote to Petrotrin to determine whether this was an authentic document, right? Mm-hmm. Did you actually get contact with Mr. Bisasa to verify it?
No, I didn't contact Mr. Bisasa, and I wouldn't do that because then I'll be accused of interfering with Petrotrin's witnesses. But
respond? You said that they did not dispute the authenticity.
Yeah, Petrotrin in a letter to Mr. Bisasa did not dispute the authenticity. We talked about other things, but they did not dispute the authenticity. And based on what they have said in the letter, it implied that they accepted the authenticity. Any other question in respect of this?
Sorry, reports are not public and that has not been presented in any way. But do we in any form know if those reports depended solely on the Petrotrin report or if they did independent calculations to confirm the initial report and then lead to the...
Well, that is an important question. All that I can tell you is that I haven't seen the Kroll and the Klein reports. Petrotrin has kept that totally secret. they're expecting everybody to rely on what they say, that it confirmed it. But based on what I saw in the supplemental internal audit report, I feel very confident that what those reports did, they accepted the data in the internal audit report, but I am very confident that they criticized the Petrotrin's measurement system, because no international company like Kroll and Klein, in the light of what the subsequent supplemental internal audit report states, would not criticize and would not make recommendations. And the only conclusion I could come to is that Petrotrin, whoever at Petrotrin, whoever the people are, they have decided not to disclose this because the public and A&V would have seen the inaccurate system of measurement of crude oil supply to Petrotrin. But the supplemental internal report has more implications. If Petrotrin is depending upon government assistance and taxpayers' assistance, and you have all these problems existing, and you do not have a situation where they're being remedied, and I read some of the things to you, it must mean that something is radically wrong at Petrotrin, and it must mean that some action has to be taken. Now, it would seem to me that, I mean, I was going to tell you, when the question was asked, if I were in government, I would have taken steps immediately to, within a month, to get some idea of what is being done with this measurement system. In the meantime, I would have restored the contract to A&V and to any other contractor until I was certain that this measurement system was accurate. And there are other problems with the measurement system. There are other problems which have to be remedied in the national interest. I do not know what the union may say if they see the Kroll report and the Klein report. And if this, I don't know if the union has a copy of this supplemental internal audit report.
You said on page 12 here that in September of 2017, months after the first reports, that there was still a discrepancy in terms of how...
Yes.
I
have a document of that.
Okay.
I have a document signed by Petrotrin officials. I obtained a copy of that. I can't tell you how I got it, but I obtained a copy of that. It was sent to me.
So the supplemental report, which is not public, said that there were problems, and then there's another document that says that problem that we didn't know of.
Yeah, it's just I'll tell you, it's a one-page document that shows that. And it may be at a future date, let's say in the next 2 weeks, I'll release all of that, probably, depending what happens. Because I think I have a duty to inform the public, but I am trying to give, I am not sure whether the board of directors knew of the supplemental report. I am not sure if the government knew of the supplemental report. So I am giving them an opportunity. I want them to see the report if they didn't get it. And I would think in 2 weeks' time we should really make an assessment of what's happening. I want to be fair to the Petrotrin board, and I want to be fair to the government. Okay? Thank you very much.